Thank you. Let's get back on the record again. This is State of Florida versus Mr. Demmons. Present is the defendant, Mr. Demmons, his counsel, these state attorneys. And my understanding is that you have copies of the documents. Is that correct?
Yes.
Ready to proceed?
I.
All right. Go ahead, sir.
Thank you, Judge. So the last document that I was listing was the state attorney's motion to prosecute. The state's memorandum of law in support of the motion to prosecute the handle of protective orders. And in that motion, I moved to prosecute this week, which was obviously not last week.
You have the time. If there's any confusion, whatever, we understand it's for this week. That's not an issue.
So, the judge, the state's argument, well, at least been because of a few things that the defense has said. They seem to want to indicate that the state is minimalizing the issue. We have been very transparent. Two ASAs have already testified. Boutros and Ms. Bradley. Ms. Bradley was even under subpoena and she testified. So to say that the state is either hiding something or trying to minimalize something, how can that be when they have put on the stand for this court to hear their star witness in a $1,000 ASA? So it's not, doesn't make logical sense that you've already put on those witnesses and there's been no evidence whatsoever that there was anything along the lines of a cover-up or an institutional breakdown from the state attorney's office. To the opposite, the court even commented last week that upon reading the deposition of Ms. Boutros and listening to the testimony of the court, there was no indication that the state attorney's office prevented anybody from saying what they wanted and actually told them, do not lie. So they have what they need. And there was nothing from either one of those witnesses that would indicate any further investigation needs to be done. But turning back to the issue today is the motion to quash and protect for the subpoenas this week. The state cites to the case of Coca-Cola, state versus Coca-Cola bottle. It's on page 2 of the state memorandum of law in support of motion to quash subpoenas. Then it's found at 582 Southern 2nd 1. It's a 450 CA case in 1990. Wherein the court ruled there was the state brought conspiracy charges against Coca-Cola and PepsiCo for conspiring to fix prices. And the Pepsi end of the case settled, and Coca-Cola was still going. And so they issued subpoenas for the state's attorneys to appear for that position and also for their records. And so in that case that outlined, first of all, any state agency such as the state attorney's office has to comply with the public records law of the state. The public records law of this state says that a state agency's work product, when it comes to public records, that's written records found in the file, not oral, are protected until the case closes. At that point, the state's file no longer can the state claim work product or attorney-client privilege on anything that's in that file, public records. Why does that happen? That happens for a reason. Because that is to allow whoever, the defendants, attorneys, whoever, can ask for all those files to be able to go through them and see whether or not they find Brady evidence or they find some other evidence to be used in 3.850 post-conviction motion. And if there was Brady found in that file, the work product, when they're looking through the state's actual physical file, they could then make that claim in a 3.850 motion, it could make it the fourth, and the entire case could be reversed and sent back to the trial. But there's a distinction, and Coca-Cola Bottling Company makes the distinction between a written product that sits in the state's file and oral testimony. They say that the attorney-client privilege for oral testimony for the state's attorneys applies all the time. It doesn't get waived because the case is closed. So it applies when it's closed, and it applies when it's open to oral testimony. So in this case, that privilege, that attorney-client privilege cloaks everything that happens between the agency, which is the state attorney's office, and its attorneys, the assistant state attorneys. And that's why there should be no further inquiry into the witnesses that are listed in the subpoenas this week. And that's why we ask for a protective order. For those of you who crossed and for a protective order, they not be issued again, because that privilege applies. The defense wants to parse out and say, well, you know, the work product privilege really doesn't, you know, and it's fact, you know, that doesn't really apply. It does, when it comes to oral testimony. And if you add on top of that, you see the reason why the court should not watch subpoenas is because there's systemic problems, institutional problems in the state attorney's office, they're not telling the truth, they're not being forthcoming, and that goes against everything that you heard last week from the two state attorneys who did testify. So today, the court stands here with these motions squashed and for protective order, which I agree with the defense. We can't really go any further until there's a ruling on these because we're kind of stuck in the war. And the court seemed inclined last week to mainly grant these motions, but you gave the defense additional time to make more argument. And nothing has changed since last Friday. That attorney-client privilege that is cloaked over the state attorney's office, it still remains. And there should be no, but it's important, it's there for a reason, and it should not be disregarded. And we let them last week go ahead with the fact. You know, they say we're not being fair. They got out the fact. ASA testified. And yet there was no indication whatsoever that the state attorney's office itself had done anything improper or wrong. If anything, it's just told them to tell the truth. So that's why, under the attorney-client privilege, we asked the court today to grant the state's motion to quash and for protective order on the witnesses the defense had set down this project for oral testimony before this court. They are protected under that privilege, and they have not shown any reason to this court, through the testimony of last week, that there should be any further investigation into the state attorney's office. So therefore, for those reasons, I'm asking the court to please grant the state's motion to quash.
Thanks.
Your Honor, obviously the court knows I just received this matter, I read it, and I'm going to do my best to respond to it. So if my argument is a little disjointed, I think the court would understand why. First of all, the state acknowledges in many of their pleadings that they waived the privilege as far as Ms. Boutros testifying at deposition and at the hearing that we had. They waived that privilege for Ms. Boutros. They waived that privilege for the subject matter. They don't have the right to pick and choose. We waived the privilege for this witness because we like what she's going to say or don't like what she's going to say, whatever their reason may be. We waive it for that witness, but we're not going to allow you to talk to these other witnesses. The privilege was waived by the state attorney's office. They've acknowledged they've waived it for Ms. Boutros. The state now today argues, well, Ms. Bradley came in here and she also testified. You had to order her to come down from, we were told it was a deposition. I've known now that she was talking to other legal authority. I don't know what the truth is, I just hear different things. But you ordered her to come down to testify. This was not the state being magnanimous and coming in and saying, please talk to Ms. Bradley. But the bottom line of it is they voluntarily waived whatever privilege they had when they authorized and allowed Ms. Boutros, A, to talk to Mr. Benjamin off the record, B, to give a deposition, and C, to testify here. That has been waived. I want to point out, and we attached it to our memos, a list of cases, and we could have gone on a lot longer, where state attorneys were called in different types of hearings, but Brady hearings and things of that nature that we're dealing with, and they're attached to the memo we filed. How does a state attorney get called? One of two ways, subpoenaed or voluntary. Bottom line of it is they testified. In some of the cases we listed, it was the head state attorney. In some of the cases we listed, it was the assistant state attorney. And they gave testimony. What does that show you? They can testify. And I don't know where the court's going to go on this, but if the state has the ability to call a witness voluntarily, or to subpoena that witness because it's a state attorney or an assistant state attorney, and we don't have that same right, that is a blatant violation of the Sixth Amendment right to confrontation, and that is a constitutional violation in and of itself. So the fact that the state attorneys in these other cases have testified, and the record is replete that they have, state attorneys and assistant state attorneys can be required to testify. Let's go on a little bit more. The focus of all of this seems to be, although it's not talked about a lot, work product. I mean, that's what it comes down to. Are we asking for work product? The state, in the case of Kidder versus State, the court said that work product traditionally protects that information which relates to the case and is gathered in anticipation of litigation. Well, then the state comes along and they file their motion, state's memorandum of law in support of an order denying defendant's motion to refuse the state attorney's office. And on page 3 of their memorandum, the state submits defendant seeks to introduce impermissible impeachment evidence on a collateral issue. The witness tampering investigation emerged from the subsequent prosecution of the instant murder charges, and not the murder investigation. And it goes on. So they're acknowledging that that does not fit into the work product into this case. They're saying that was a separate incident and not part of the investigation of this criminal case. So therefore, it is not work product as to this criminal case. Now, the corollary argument from the state is going to be, well, it's not related. It is obviously related. Those are two different things. One is an investigation of this case, and the other one is whether it's related to this case. It's a tampering of evidence. Well, first of all, let's go back to what occurred. Ms. Boutros testified that it did not have any case number on it when they sent out that subpoena that caused all of this. It had only an internal case number. She further testified that it possibly could have been used at trial, the tampering in the murder case. And the state in their pleadings turns around and says they are not going to use any of the tampering evidence in this case, the murder case, acknowledging that they believe that they would have the right to. What can be more related? What's more related than the defendant's mother coming in for under a subpoena? And as Ms. Boutros told us, half the questions dealt with what was going on in dealing with the murder case and would have evidence to the murder case. She said it morphed into that. They're so intertwined and related, but this was not done as part of the investigation of the murder case. They just are intertwined and related. Now, there are a couple of things that I don't want to jump over, so I'm going to get out right now. You heard from Ms. Bradley. And Ms. Bradley on the witness stand several times, I counted at least 2, may have been more than that, stated that Detective Moretti asked whether Deputy Burrell was outside when the subpoena was served. Yet if you look at their Brady notices, which the court has. It doesn't read that way. It reads, this is just the last line. The undersigned spoke with Detective Moretti in regards to this incident, and Detective Moretti said he asked Deputy Gorel if Deputy Gorel was there when the phone was seized. Was there, not outside. Miss Bradley went out of her way to keep on saying outside, yet her Brady notice says there, and the one by Assistant State Attorney Killoran has there in it. She changed her testimony. She changed the wording. Your Honor, I don't know what you think, Miss Bradley. That's your opinion. But from what I'm seeing here, in our opinion, she plays hard and fast with the truth. And I think we need to talk to the state attorneys to find out what did she say to them. Was it there or outside? If she specifically said that he asked whether the deputy was there as opposed to outside, she's perjured herself in front of you. And I would assume that this court wants to know whether it has a state attorney that's willing to perjure herself to keep this case alive, because we know she was willing not to turn over the Brady material to keep the case alive, and we know no investigation ensued about Detective Moretti to keep the case alive. So I think this court has a duty for the court to know what's going on. Also, Your Honor, I can't figure it out. There's a Brady violation. And so we don't get the information. And now the state, I would think that State Attorney Pryor would be begging to come in here and testify to set the record straight of what he did hide or what he did not hide about the good intentions of the State Attorney's Office. What are they hiding? Obviously they are hiding something because they're fighting so vigorously for us not to know what occurred. The state also says, you know what? We've gotten all that we want, all that we need from the testimony that you've heard. Not true. You did not allow us to go into what was said back to Ms. Boutros or Ms. Bradley. You only allowed us to go into what they said. We do not know what occurred. We also know from Ms. Boutros, she was not there at every meeting. So they tell Ms. Boutros, you talk to Mr. Benjamin, you do whatever you want to do, you're doing a great job, thank you so much. We don't know what they said behind closed doors as to, we need to deep six this will destroy the State Attorney's Office. We have no idea. We have one part of the jigsaw puzzle. We need the other pieces to figure out where we're going on this. And I think it's the duty of this court, and I apologize if that's a proper word, but I believe it's the responsibility of this court to look into this matter, to find out what's going on. It's not work product. We're entitled to know what went on, and the only way we can vindicate our rights to show that this whole prosecution should be shut down and dismissed because this was an institutional bias and this was an institutional decision to withhold Brady material is by taking Killoran's, Pryor's, and Falk's deposition. Have their testimony. Thank you.
Just in response, this has been happening all along in the case. The defendants just make statements. This is Brady. This is Brady. This is that Ms. Bradley is lying. Ms. Bradley is lying. They make these statements. They throw them out there. There's been no determination by this court or any judicial body as to whether or not the statement made by the detective was Brady. We haven't gotten that far yet. So to keep just throwing out what they think has been found isn't fair because it's illogical. Those issues that the defendants brought up about the tampering case and the collateral, those are all going to the accuser. Those were filed by the state in response to the accuser, not to the motion to dismiss or decline. And so he's trying to mix apples and oranges when he says that the state is trying to say that it's a collateral issue and therefore it doesn't apply to the murder case. But here, we're just talking about the motions to cross subpoena and for protective order. When we get to recusal, they can argue whatever they want to argue as to collateral or non-collateral as to the tampering evidence. They had Ms. Boutros. Ms. Boutros decided on her own to waive her privilege. She waived the attorney-client privilege. It happened way back when she talked to Mr. Trafford right after the alleged incident happened. She talked willingly to the defense and gave them everything. So we looked out. We said, okay, for her, it's waived, and she can say whatever she wants on the stand. But the other attorneys did not waive their privilege. It still holds with Mr. Pryor, it holds with Mr. Paul, and it holds with Mr. Pillen, and it still holds for Ms. Bradley, as we tried last week, to limit the best we could her testimony when she was called to the stand without subpoena. One of the things the courts have said is that as a matter of public policy, that the criminal justice system cannot work properly if the state attorneys, assistant state attorneys are going to continuously subpoena for any type of deposition, oral testimony, if they're constantly being subpoenaed, they're not going to be able to do their jobs. The criminal justice system cannot work efficiently as a matter of public policy if you are issuing subpoenas to the state attorneys to get behind what's their decision-making process. And no matter what they say, what they're trying to do here is to get to that decision-making process. They even in their own motion, their response, say, then page 7, number 5, and what actions did they take on this issue, if any, and when? They want to get into the inner workings of the city attorney's office, the thinking, the opinions of the office, which they're absolutely not allowed to. The attorney-client privilege holds. And the fact that they already have 2 ASAs testify is clear indication that the office has allowed them to look into the issue of what happened that day, at least the factual issues of what happened that day with the detective. And nothing that was said from those witnesses indicated anything further. There was a conspiracy, there was an institutional breakdown, that the state attorney told them, don't tell them this, or don't say this. There was nothing along those lines. And so they seem to want to make it look as though the state's hiding something, that Mr. Pryor is not being open, but they have no proof of that whatsoever. There's no indication to this court of that whatsoever. The court even said that on the record on Friday. And I believe that portion of the record is attached to one of the state's motions that was filed, a memorandum of law that was filed on Monday. So, again, I would ask the court to maintain its thinking from last week and to quash, grant the state motion to quash and to put it for effective order.
Just 2 seconds. The state just argued that they allowed Ms. Boutros to testify and to talk to Mr. Benjamin and everything, whatever. And then they say, but not to the other state attorneys. From the cases that were cited here that I only got to read the blurb, it appears that that privilege is the state attorney's office privilege, not the individual state attorney, assistant state attorneys. So when they waived that privilege for Ms. Boutros, which the state has acknowledged again they did, they waived the privilege in this area. Also, I mean, this argument that the state attorney's office will be inundated with all these things. This is one of the most unusual cases that you're ever going to have. I've been practicing for nearly 44 years, and I thought I had seen it all. But this is the first time I've seen anything like this. So for something so out of the ordinary as this, for the state then to extrapolate saying, well, every case will have to look, be deposed and whatnot. No, this is a special circumstance where the state, regardless of what Mr. Klinger says, withheld Brady material. A trial went on a first-degree murder case where the death penalty was being sought. A whole trial occurred, no Brady is given, and then several months afterwards, when we start uncovering things that are going on, we get Brady. There is a cover-up. I don't know why. I don't know why there's a cover-up, but the fact that Mr. Klinger is here today and is arguing so vociferously for us not to know what occurred, that's the definition of a cover-up. Thank you, Your Honor.
It's your motion. Anything else? You have the last word.
There is no cover-up. And all the history that I've worked in this courtroom, I don't ever remember seeing the state attorney, the elected state attorney called into the courtroom to testify. It doesn't happen, and there's no reason for it to happen here. They have every right to invoke their attorney-client privilege. They have the information they need to make the argument to this court whether or not a statement made by the detective was Brady. That's one of the main issues, and the secondary issue is recusal of the office and or mistrial. So to say that there's a cover-up because the state is employing its right to attorney-client privilege, which extends separately to each attorney, it doesn't get waived across the board, is outrageous against the law. And also, there's no reason to haul the state attorney, the chief assistant state attorney, and other ASAs in here when nothing has been shown that anything was improper or done wrong. They were allowed to testify and told not to lie, and they did. Then we ask the court to please grant.
Hey, can I see you sidebar for a second, please?
housekeeping is, we start on Friday with the motion to dismiss. And then next week we have, I anticipate we're going to be doing motions to suppress. Each one of these motions, I would be calling Ms. Boutros to testify just to the credibility of Detective Moretti. So I'm wondering whether I need to bring her back for 14 motions, or can we accept her testimony that happened the other day and not have to keep on bringing her back, just because all that she's going to be there is for the credibility of Moretti.
No, she would need to be called back again.
Okay.
All right, I don't know where this is all going to end up. Right now, you referred to the position of the state. I don't know what the law is on it, but they'd be objecting to having her testify for transcript of the hearing yesterday. That's the information I gather. I don't know what the law is on it, so my thought is, you research the law, and if you think it's different, when you file a motion, we'll set it down for hearing, and we'll move on. Okay? Fair enough? Fair enough?
On the motion to recuse, you have not ruled on that yet.
Now,
I guess I need to know what you're doing on what we're discussing today, because I would be asking the court, since you haven't ruled, if these witnesses are allowed to testify and you have them here, I would ask you to keep that ruling open until we know what they say on that motion.
understood. That's why I gave you a chance to present your argument today.
I kind of thought you were there.
All right, so we'll see where it goes from there.
And the court,
Thank you.
well, the court told us that we could have a ruling for us.
No, I understand.
And he's asking about the motion to recuse. You got the motion was their memorandum on the motion to quash, things like that. I'm going to rule on that today.
Thank you. That's fine, no, the refusal, I understand.
Thank you, Your Honor.
Appreciate it. Thank you.
So right now, we're on for 9 o'clock on Friday, unless we know other stuff.
Yes.
Thank you.
Thank you. Thank you. Have a good day.
Did you think with that?
The hearing's concluded.